News. Get the whole story.
Welcome back. You're watching Siasa Fiesta here on Morning Prime. Paul Gicheru is appearing at the Hague today, ICC, regarding, of course, witness tampering in the Deputy President's trial, which is, by extension, they say, his trial, because this was witness tampering during the 2007 post-election violence. What does it portend? We'd ask for the Deputy President right now. Tiende says this is not really going to put any ripple effect as far as the presidency or that particular running for presidency of Dr. William Ruto is concerned. And this is bound also to just, of course, put that sympathy vote for Deputy President William Ruto on the run. Let's just hear from Aaron Cheriot as far as this development is concerned, then we move to another story. Briefly,
well,
your reaction.
I don't think this portends much for the Deputy President. In fact, the only reason why he's here is because it's an attempt to make it newsworthy and rope in his name, just hoping that in the usual sense, given the past history between ICC and this country and himself, that it will be a big story. But I don't see anything of that sort. First of all, let's not lose sight of the fact that Paul Gicheru actually took himself before the ICC with regards to this particular matter and said he wanted to clear his name because he had been accused. He wasn't arrested, there was anything about extradition.
But there was a warrant of arrest.
Yes, of course. Yes. But no, I don't think at that point a warrant had been issued against him. There were summons or something. I'm not very clear about what exactly was in place for him. But the long and short of it is that on his own volition, actually, he left the country and went to surrender to ICC and said he wanted to clear his name. I've had occasion to ask him, because this is a gentleman known to me personally, what is this about? He says, I don't want to live my life with people thinking that I did the kind of things that I'm being accused to. And he says, I never paid anybody not to turn up. The whole ICC circus in Kenya is something that is best left to lie somewhere in the shelves, because we all know what actually happened with regards to the whole case about what people are saying, how these witnesses were procured. There have been confessions and counter-confessions about, oh, we procured witnesses trying to fix this side of the political divide or the other. And therefore, it was just not a good experience. In fact, I think in the ICC training manuals of his prosecutors and everything, the Kenyan case will continue to be quoted for the next number of centuries because of the level of misadventure that it turned out to be for them. Because, you know, you come into a country thinking that everybody that you speak to is speaking the gospel truth, but little did they know that this is Kenya. And Kenyans have a way of going about their things, that sometimes actually for money, people can say certain things, and later on for a higher amount, they recant everything that they said. And that didn't leave the ICC looking good before our country. And basically, to the best of my knowledge and my analysis of what I think what happened to ICC, it was that's a whole story of what happened in this particular case. And therefore, it's quite unfortunate that it's coming to this now, trying to say ICC is trying. Actually, it's a face-saving attempt by ICC just to say, because the accusation, remember, the case fell on the basis that the witnesses could not be trusted. Many of the things they were claiming, when they were put through the test of common sense, like the things they used to claim and say, oh, there was a meeting where 3,000 guns were distributed, you know? And when that was put through a logical test and people are being asked, who was there? How can 3,000 guns be issued in someone's compound? You know, most of the things that they alleged failed actually the logical test before an independent court of law. That's why the judges actually dismissed the case. And therefore, right now, this is an attempt by ICC, in my honest opinion, to face save and try and say, no, 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 no. We think our witnesses were credible, but somebody interfered with them or made them. And I think, just like in the main case, they were found not to be credible. Even in this round, they'll still be found to have been people.
Yeah. Briefly, yes. Then we wind up on it.
Yeah, just a brief one. You know, a court case succeeds on evidence. And if the witnesses are not going to testify or have turned to be hostile, which means that from the statements they presented now, they are denying them or have changed their story, then it means this matter is going nowhere. And I don't think we should pick much out of it. We should just let it rest and move on as a country. I don't think we expect much from Gicheru's case in The Hague. Yes.
All right, thank you. And I think it's a good point also to just rest it as well. And we move on to another topic. Right now, we know the party primaries are looming. March 26 is a big day as far as, of course, also nominations are concerned. And as I mentioned, the political parties registrar is putting every duck in a row to make sure that the new act that we do have, the Political Amendment Act, really come into force as well. I just want to hear from Otedo Molo on that particular development with the new acts so far, especially on where we had bugbears and fears in Parliament, in the floor of the House. You know, people that are leaning towards the UDA or the Tanga side were saying the political parties registrar will really have an ironclad, sort of clinch as far as the nominations is concerned. She's going to control. Is that true? Is that what that particular act really portends? What is the way forward as far as the nominations are concerned?
Well, first of all, the basic backbone of the amendment was really to anchor a law upon which coalitions can be built. Until then, we had coalitions, but which essentially were unregulated by law because there was no proper anchorage. And that is really the basis.
Yes.
So contrary to what Aaron Cheruiyot and his friends said then and continue to say now, they were the first to embrace it because immediately the law was passed, they were then able to have an anchorage upon which they could ask ANC and Ford Kenya to join UDA in what they are now calling Kenya Kwanza. So in terms of benefits, although out there they kept saying and they've kept saying that they were opposed to it, they are the first to embrace it. That is really the anchorage. Beyond that basic anchorage, there are other amendments that were meant to streamline things, including streamlining the idea of nominations. And one of them is that until now, until we did the amendments, party primaries were really open to anyone. Okay, you could be in UDA, and as you are conducting your party primaries, if it's an area that is also strongly with ODM, you could have ODM candidates choosing the weakest person in UDA to vote for, so that when it comes to the main election, then they beat him, and vice versa. And that happened in very many places. So you are having people who are non-party members actually influencing the outcome of party primaries. And that is why we now insisted that only members of a political party should participate in that process. But beyond that, it still allows a party the choice. A party can make any of those choices in terms of what is the best mode of nomination. Do we do direct primaries as traditionally, like those of us in ODM do? Or do you do the more direct one, like traditionally those in Jubilee have more or less always done? Or do you use the delegate system, where you agree on the number of delegates who then choose the candidate? All those options are there. But more importantly, I think now, the registrar has laid down, and this is important because there are many people who don't yet appreciate how tight a deadline we have in terms of finishing this issue of primaries. You know, a lot of people still think we will get to June, July, to determine who the candidates are. They don't realize that with the framework right now,
you're really pressed for time.
We are really pressed for time. All the parties are basically talk of barely 2 months, less than 2 months actually, to finalize this issue of party primaries, and then we now move on to preparing for the election. And I think that is not a bad thing. There's one common challenge that all the parties will have a challenge that is common to all of us. In Kenya, people belong to political parties by persuasion rather than by registration. You know, so you will say this is an ODM zone, you know, this is a UDA zone, this is a Wiper zone, whatever it is. And many people there tend to sympathize with that particular party. But if you ask them, how many of you have registered as members of that party, then you find they are quite low. So the common challenge we all have is really to educate, even as we've been educating people to register as voters, you know, to take IDs, register as voters. It's at the same time to educate them that you need to make sure you are a registered member of that particular, particular political party. But that's a common challenge, because however much we do it, and we are doing it, you will still have a substantial number who will not have registered by the date of nomination. And that is the challenge that will be faced, that you now have 800 people who have turned up, only 100 are registered, yes. The other 700 demand to vote, and they're being told you cannot vote because you are not registered. How the political parties handle that will be important to the outcome both of the primaries and even of the election itself.
Mm-hmm. Aaron Cheruiyot, you wanted to comment on that briefly, and especially for UDA. And I know nominations, this will be the first one. We can see people still, you know, raising special umbrage and the way, you know, this whole affair is running within your particular party. We have Ngirisi, who has actually bolted out because
not necessarily.
Things will not be really fair as far as nominations are concerned. So there are bugbears, jitters and fears within your party.
Of course, those are the challenges of being the most popular party in the country. You'd expect that everybody is trying to seek your certificate, and that is expected. But there's nothing new. When I look at the people that are tasked with this responsibility, there are people who are up to task. For example, the UDA Secretary General, Veronica Maina, is a lady who's very well versed with political issues. I remember when I joined Parliament way back in 2015, she's the one who ran actually our Jubilee Party primary. So she's no stranger to this kind of work. She has been there and understands the challenges together with the National Elections Board. However, back to this main topic, there are things that I agree with Otiende in what he's trying to say, but the folly of this Political Parties Act, and that's why many of us poked holes in many of its provisions, is that it is based on certain assumptions and certain misinformations. Misinformation such as part of the law was largely touted as being the Achilles actually that will hurt UDA in terms of its popularity and not being able to properly execute. You know, the unfortunate thing being that people imagine that a bad law can only be bad for one section of Kenyans. Unfortunately, if a law is good, then it is good for all Kenyans. If it is bad, it's bad for all Kenyans. Number one, for example...
Weren't you really over-reading also yourself as a party and over-braining it?
Yeah, that's why I want...
Then you discovered along the way it's not really a bad...
if you allow me to break it down, then I'll do it. This is a thing. Number one, Otiende speaks in blowing tribute about this issue of coalition political parties. And I've mentioned this severally, that based on what I have seen about political party coalitions and our Jubilee experience, and you can see also NASA and previously CODE has been victim of these issues of mistrust where people agree on one thing. How, for example, do you have a contestation such as what I referred to earlier on what was agreed when we win or lose? You want to tell me a man of the stature of Kalonzo Musyoka can be so ignorant to the point of signing an agreement that is only one-sided? I mean, honestly, it is common sense that if you're going to an election that could go either way, you sign an agreement saying, if we form government, this is what will happen. If in the unfortunate event that we don't form government, this is what is likely to happen. It's logical. ODM would rather not refer to the side of what was their expectation. But that's not the main point. My main point is this: coalitions, in my honest opinion, are based actually on mutual trust and respect, more so actually like a gentleman's agreement. If the person that you're doing the deal with is not honorable, it doesn't matter what is provided for in ink and paper. And I've always cited the example of the president and his deputy currently. You know, despite, forget about this law that Akina Otiende are touting, the deputy president has his position firmly secured in the constitution. But has that stopped his coalition partner, that is the president, from shortchanging him and ensuring that he doesn't partake of a government which they formed together? What does it tell you? It tells you that the art of coalition building is more than just putting it on pen and paper. It's about hygiene, about the people and the track record. And that's what I want to believe informed the decision actually of Musalia Mudavadi and Senator Moses Wetangula in picking their side of the political divide. They'd rather be comfortable with someone they look at and say, this has been a victim actually of past machinations just like us, and probably would understand what we say when we say we want a meaningful engagement with people who can be trusted, which is what Wiper keeps on referring, because I've watched many of their press conferences, that we shall not enter into a coalition agreement with partners who cannot be trusted. Therefore, a law on its own cannot be sufficient, and that was our argument. There's something else, and the gentlemen that are with us here are lawyers of good standing. I don't know what was the wisdom in apportioning the responsibility of actually almost regulating the nomination process of political parties to the register of political parties. Yet constitutionally, if you read Article 88, subsection 4E of our Constitution, that is squarely an IEBC mandate, because it reads the settlement of electoral disputes, including, actually D, 44D, which is the regulation of the process by which parties nominate candidates for elections. It's squarely a constitutional mandate that is given to IEBC. Yet, by this law, there are people who, since they are not comfortable with IEBC and they cannot manipulate and control it the way they can do it with an individual. You know, register of political parties is one individual. Somebody who can easily be called on one afternoon and told, the register Dan Manzo from being a member of Wiper. And that is a risk which the drafters of our Constitution perhaps sought to seal by ensuring that you have this very important task in the hands of a commission. You know, the thing that makes me comfortable about IEBC is that it's a commission. It's not a one-man show, such as ORPP. Take, for example, Otiende, the challenge that political parties are facing right now. Many political parties are saying, our members actually are not in our party register. And people remember yesterday, in such a low-key ceremony, they launched a USSD code for people to resign from one political party and join the other. Yet, the system actually continues to have hitches. Therefore, the political party that Dan belongs to, and even this Otiende who supports this particular law, just like those of us who are now supporting UDA, will experience this challenge, because his voters will go to Rarieda, a particular primary school, and they want to nominate him. Then they'll be told that unfortunately you cannot participate in this nomination because you are not captured in the list that was released by the registrar as being a member of ODM. You can imagine the amount of chaos that will cause my good friend Otiende back in Rarieda. These are the challenges which, as political party players, we shouldn't be trying to set on the way for political parties, imagining that it will, unless maybe they have changed their nomination process and they don't want it to be universal suffrage. I think there have been such similar suggestions from ODM. But for those of us who still want to do it under universal suffrage, then this presents a difficult challenge. And many of such provisions are the basis upon which I think this law will fall actually in the courts of law. I saw last week that there are, what is it called? There are, I think, Katiba Institute or something. Yes. They went to court on many of these provisions. And I think on basic reading of the Constitution, many parts of this law will be declared actually an nullity.
Thank you. I think Aaron Cheruiyot is really raising or teasing out a very interesting perspective on this. Is this looking at this particular Article 88, E, where he's really talking about the settlement of D, that is the regulation of the process by which parties nominate candidates for elections. Is it duplication? Well, now we have also the Political Parties Act also coming into play as far as this is concerned.
Well, I just want to ring in a little bit. First of all, you cannot legislate on everything. You see, and again also, the Constitution does not cover every bit of every process. And therefore, there is a role played by IEBC, and there is a role played by the registrar of political parties. In this particular case, although we have made a law, and every time a law is passed by Parliament because of interest, then people are free also to go to the High Court, and part of those texts which are contradictory or contradict the Constitution can be held to be null and void ab initio. And therefore,
but that is what we're trying to avoid, you know, wasting time in court or over matters that are, they're very clear in the Constitution, yet you're raising other legislations which are countering or maybe duplicating the same.
The moment you raise it in court, the court is supposed to interpret, and that interpretation is still challengeable up to the highest level of court. And therefore, we had a problem. You see, when legislation is made, you are trying to cure mischief. Universal suffrage had its own mischief, meaning you let all people go and vote for their candidate. Then you have people repeating themselves, voting and coming back to vote at the political party level. In fact, no political party in the country has full structures to conduct a proper and a fair nomination, really, in the country. That capacity has not yet been built. And one way of doing it is having party lists. The moment you have a party list, for the first time, some people will not participate, but as time goes, people will be able to register in political parties. And in fact, that's what Kenyans should be doing now. They should be registering in political parties of their own choice, so that you have an opportunity to participate in nomination. Otherwise, also, political parties have several options. In the nominations, you may agree as a political party, these are our candidates, and we present that to IEBC. And then you may decide to have a process within the party to select the best candidate of the party. And a lot of times you select a candidate who is not popular with the people, and therefore they end up losing in the main election. So it is work in progress, and I believe as time moves by, we'll be able to purify this and make it the best for the country.
Uchenna, briefly on this. Then we run up.
The issue, the point that Aaron raises is true in terms of the reading of the Constitution, and in our debates in Parliament, I pointed that out. But it is not true that the amendments contradicts it. Okay? If you look at the Hansard, we had that long debate, and we explained. First of all, I will have you know that the intention of Article 88(4)(d) was just that. The one that Aaron has just read. Yes. When we were writing the Constitution, we came to the conclusion that most political parties are usually not democratic in conducting the party primaries. Yes. And that there was need for another body to be involved. Unfortunately, from 2010 when we passed the Constitution up to even now, subsequent chairs and commissioners of IEBC took the view, and I personally, when I was the Ombudsman, I raised this with the IEBC, that they need to come in and, using the words of Article 88(4)(d), regulate the process of party nominations. The IEBC has not, up to now, since 2010, for now 12 years, purported to regulate that process. So in 2013, in 2017, they left it entirely to the political parties, because they took the view that it is not their business to help, to determine for parties what to do. Okay? Which means this is a responsibility the IEBC has consistently run away from. If the intention as it was remains true, then it was therefore necessary for us to find a way of putting this responsibility then on someone else who's willing to deal with it. And that someone is the registrar of political parties. Let me just explain. In doing so, it does not, and this is the second point, the point that IEBC has made, and sometimes in retrospect, I think with some reasonableness, is that they do not want to involve themselves in the conduct of the party primaries, and yet they are also supposed to make a determination on disputes that arise from the party primaries. So they would rather, pull away and maybe deal with the disputes, but even the disputes from the party primaries, they really don't want to. Because when it comes to the election, the main election, again they're involved. So what the IEBC has argued for the last few years, that look, let us not involve ourselves in the party primaries in terms of conduct. In terms of party disputes, in terms of disputes arising, let us get other bodies, and that is why we now have the political parties tribunal, where we even expanded lately. We now, I think, we'll have almost over 20 people, okay? And that is why even you can go up to the High Court. Because the IBC wants to really pull away from the conduct of primaries. So it's not usurping any of their role. It is consistent with their request. But the third point to note is that the IBC still remains the body in control because it's supposed to control the process. Even if the registrar now controls the actual conduct of the party primaries in liaison with the political parties, that does not usurp the ultimate role of the IBC, because ultimately the IBC is superior in the constitutional ranking. It is the constitutional body. The RPP is not a constitutional commission. And so the role of the registrar of political parties is merely complementary to that of the IBC, and that ultimately is why it is not inconsistent. It's not a usurpation. In fact, it is helping the IBC itself do what it has always wanted to do, which is not to get into the nitty-gritty of how parties conduct themselves, not to get into the disputes when it comes to the party primaries.
Of which they should have been actually doing it.
Yes, and that's why we went ahead. And now there's an elaborate mechanism in terms of how to conduct those disputes that arise from party primaries, including even questions of expulsion or withdrawal from parties where there was no clear mechanism. So in my view, this whole process is actually complementary and helpful to IBC. It does not contradict. And the registrar understands that the limit, that her role is complementary to that of the ultimate role of IBC, because it is a constitutional body.
So had IBC, played its fullest role in that particular demand from the Constitution, then we wouldn't need this particular...
In my view, yes. If IBC had come to the conclusion, you see, you can be one body, but you constitute yourself differently. You can say there's this department that only focuses on party primaries, where it does not touch anything beyond that. Then there's this department that will only focus on the disputes that arise. There's this department that just focuses on the actual elections, because all those ultimately are subsumed in its jurisdiction. But the IBC took the view that it is one body and it cannot do all those things at the same time. And basically it pulled back to just await the main elections, to regulate the conduct of the general elections and its outcome. And that's why it was necessary to do this, quite honestly. And having been on the scene for some time, having a body that regulates and looks keenly into how parties do primaries is a good thing. In fact, party primaries in this country used to be hogwash. It was chaotic. It is only since the new constitution that there's been a consistent attempt, and with every election cycle, party primaries are becoming more democratic and they're becoming better. Hopefully we'll get to a place when we can say that the primaries are fair. Right now, if you were to ask me, as of 2007, on a scale of 1 to 10 in terms of democracy, I think it was at between 1 and 2%. At 2013, it improved to about 5 or so percent. In 2017, I would put it at about 7 out of 10. Hopefully we'll get to a place where we can say it's between 9 and 10 out of 10.
All right, so with this new development we have with the Act, maybe there's some sobriety will be seen. And I was expecting that you'll say ODM is the only party that has actually...
I had said that before. I said we are the ones who usually conduct primaries. The rest usually pick. They say, Aaron, this is yours.
When is the last time Wiper conducted primaries?
They don't even attempt.
It's my turn. I'll tell you by the way about...
It's done Mazu's turn. No. But it's just... this is just briefly. When did you conduct your last primaries as a Wiper party?
We all conduct primaries. We all conduct primaries, and they present a candidate. And in our case, 90% has been successful. Where we have presented a candidate who have lost to an independent, is a very small percentage.
Thank you.
Yes.
No. That's what Otiende is saying is not true. Anyway, order is relative. What is orderly in Homa Bay is not orderly in Kericho.
Order with the men in black.
The ODM status of order. That's why I always tease my friend Outa, the senator for Kisumu, that his nomination certificate was actually issued at Miwani Sugarcane Plantation, because that's where I saw the returning officer for Kisumu making the announcement in a safe house. Yeah, otherwise it was not possible to make the announcement in Kisumu. I don't know where the Otiendes was done. It must have been somewhere on Rusinga Island, where the men in black could not quickly swim to. Anyway, anyway, that's besides the point. Here's my struggle with all this arrangement. You know, the folly about all these laws that are generated by the thinking of the so-called deep state, or now being referred to as the evil state, is that many of them, unfortunately, are done with a particular thinking. And that thinking is how to shortchange constitutional order. If this law had been done, you know, what kind of logic is this that Otiende wants to give us this morning? That because IBC, and he fully understands well the challenges that have bedeviled that institution for the last 2 election cycles, because they've only now had chance to run 2 elections. That's the 2013 and the 2017 elections, and under different leaderships. It's only now that we are actually trying to give the institution a lease of life. Otherwise, there have been always the process of interference by the political elite pushing for removal of a chair, certain CEO, and you know, all that kind of challenges. That because they have failed to take up a particular responsibility in the manner and the way that they should, then you should change actually the constitution and give that power to a different institution. I don't think that's a fair and a good argument that we want to give to Kenyans this morning. Our demand, and especially us as lawmakers, would have been that we push IBC to actually make that decision. You know, so poor in drafting is this Political Parties Act, to a point that even independent candidates are now being directed to the Register of Political Parties in terms of assigning them the party symbols upon which they are supposed to use, you know, the way independents are given a particular symbol to run on. Yet this is an individual who from the very onset has elected not to belong to any political party. But here you are subjecting them to the machinations of a registrar of a political party. You know, so this law is filled with so much flaws, which unfortunately, because you know the thing and the general thinking in both the Senate and the National Assembly when it was being passed was that, let's just pass this law to finish Ruto at that particular time. And there are many things that slipped under, because ideally, had the law been left to the National Assembly and Senate to work on it, I'm sure that JLAC of both houses would have done a decent job. But unfortunately, these are part of the laws where phone calls begin to come in and you're told, oh, don't touch a comma, you will mess. In fact, somebody has informed me, somewhat in good authority, that by the time Senate committee was considering this law, it had already been printed at government printers. And that's why on that particular evening, because I speak, these are our colleagues, members of the Senate Justice and Legal Affairs Committee, while they had very important amendments which they felt that it was important that they be introduced, they were told not to dare touch a comma, and which is the unfortunate thing about Parliament as presently constituted. Why would you, for example, as a member of Parliament, and this is, I can't understand this current lot of Parliament, because last Parliament, and Dan Manzo will be my witness here, we had almost a similar law that came around this particular time from the big boys in town, and part of the provision included locking out members of Parliament or political practitioners who don't succeed in the party nominations from jumping ship and running on independent. At least then, there was collective thinking, and you, if you do recall, well done, people said, much as we love our party leaders, we cannot grant them this amount of power, that to a point that somebody can prematurely end your career. Because if you're denied a party ticket, if that law had been passed as it was then in 2017, many of these independent MPs that you're seeing will never have seen the doors of Parliament. Because actually, I think 90% of them had participated in a party primary. They were dissatisfied by how the process was conducted, and they chose to run on independent. And to prove that the party was wrong, they actually won.
Thank you.
But as it is right now, this current lot of parliamentarians, I fear, because part of the election amendment bill that is now before them and I think it will be read the first time today in the National Assembly, wants to close that window again. I'm not sure if these guys will use the collective wisdom of 2017, or then again they'll be lied to and told, don't worry, this is about trying to contain UDA. And they'll foolishly pass it then only for them to realize that they have actually it's a self-inflicted injury on themselves as political party players.
Thank you. Thank you. Unless maybe there's any pending issue in this. There's a new development that we have here or regarding IBC. Remember last week we were actually looking at this editorial cartoon on IBC and the servers. So there's a man who has actually gone to court that is preventing IBC to conduct the general elections until he's actually petitioning the court until they open the servers as well. And I want us maybe to couple that with the conversation that we have also, or a story there on page 8 of the Standard, where a man is seeking to stop also IBC from barring non-graduates, right? And that is a lawyer has accused the Electoral Commission on secretly seeking to bar candidates who lack degree certificates from contesting the position of Member of Parliament in the August 9th election. Adrian Kamodo, in his petition filed at the High Court, claims the Independent Electoral and Boundaries Commission deliberately failed to specify the qualifications for MPs when it gazetted the election date so as to lock out those without degrees. It goes further there. But yes, this is bound to happen even as we're going towards the general election. Can this trip the wire of IBC in any way? Maybe we can make it more clear also what that particular story is saying on page 8 of the Standard. Senior Counsel.
Well, let's start with the server.
You start with the server.
You know, this is an unresolved matter between me and Aaron Cheriot for the last 3 years. And there was a time Aaron Cheriot dared in another forum where we were with you and said that the servers had since been opened. and then we dared him to now share with us the outcome of the result, and he has never done that to date. So may it just go on record that the servers have never been opened, despite the assurances by Aaron Cheriot and others. And so, on a different note, when therefore the IBC summons, and I will not speak too much on this, because I'm going to accompany Sabina Chege to IBC, when they summon Sabina Chege, when she says that the elections may have been stolen, you know, they must do it tongue-in-cheek.
Yes.
Because only if they had opened the servers can we know whether those allegations are true or not. And so maybe we might have the opportunity of them opening the servers today when Sabina Chege appears. And then we can look and say, maybe she lied or she did not lie. But having said that, it is true that the Supreme Court, in very clear terms, required the IBC to open the servers. It is true that the IBC used every flimsy trick on the book, including saying that the servers were asleep somewhere in Spain, not to open the servers. And it is true that the Supreme Court then took the easier route. The easier route was then to order, fresh elections. The more difficult and better route would have been to insist that the IBC must open those servers no matter what it takes.
Yes.
But you see, now the Supreme Court was constrained in terms of time, because there are timelines within which they must finalize the matter. There are timelines within which any fresh election must be held. So the fact that the Supreme Court ordered fresh elections does not exempt the IBC from the need to comply with those orders. So those orders remain uncomplied with. And going to court to force them to comply is okay, except I am not quite sure which court the gentleman has gone to. I have not seen the story. But you see, usually, when you want compliance, you would go to the court that made the orders, which means they would need to find a way of going to the court, which is the Supreme Court. Traditionally, it would be by the parties that were involved. But for those of us who are involved, once the Supreme Court ordered fresh elections, and they were held without compliance with the orders, and then thereafter validated it, we really lost interest in further pursuing that particular line. But that does not exempt the IBC from compliance. And it is true that the veil of lack of transparency will only be removed from the IBC the day they open those servers. Coming to this other story, in terms of my colleague Adrian Kamoto suing the IBC, again, being that now he's gone to court, perhaps we wouldn't comment too much on the merit, but I dare say he's flogging the wrong horse. The idea that you need to have a degree to vie as a member of parliament was not introduced by IEBC. It's in the Act. And only that the last election, parliament exempted the application of that section. But for this session, to the best of my knowledge, parliament has not placed any such exemption. It remains, therefore, that for you to vie as a member of parliament, you would require a degree. If Adrian Kamoto wants to challenge that, he should not quite challenge the IEBC. Because the IEBC is just the implementing agency. He should actually challenge Parliament.
Yes.
And he should challenge that on the basis of unconstitutionality. He should demonstrate which part of the Constitution makes that discriminatory. And I dare say this, you know, there's been some tendency, and I'm happy the Court of Appeal lifted this, like, for example, when the court said that even those who want to vie, who are still public officers, don't have to resign. That was dangerous, because Parliament makes decision on its wisdom, having consulted with the people. And there's good reason why you cannot be a member of Parliament, you cannot be a public officer, and then you want to vie at the same time. Take the example of our friend Natembeya, okay? He had to resign because he's going for the governor of, is it?
Trans Nzoia.
Can you imagine if, for example, he was actually the county commissioner or the regional commissioner for that area, and then he's also going to be elected, and that he's allowed to hold both and do both up to the date of election? It would be chaotic. So sometimes some of the courts, especially the High Court, have tended, instead of just applying the narrow test of constitutionality, the narrow test is if Parliament passes a law, then it can be struck down if it is unconstitutional. You must show which part of the Constitution it is against. But sometimes the courts supplant Parliament, and then they want to come to the question of reasonableness. Is this law reasonable or not? Is it good or not? That is not the business of the court. That is the business of Parliament. And that's why parliamentarians are elected by the people. So one like this, I am one who believes that you must at least have some standards, okay? You must have standards when people are coming to debate in Parliament. And we've seen some of our colleagues who find great difficulty dealing with legislation, dealing with debates, because they can hardly comprehend. I think it is a good thing to insist that in this day and age, for you to be a member of Parliament, you must at least be a graduate. Now, I agree that for MCAs, you don't have to insist on a very high standard of being a graduate. You can insist on some secondary qualification. I am okay with that. But on this one, I think it is for good reason, and I think Adrian assumed the wrong party. I hope the law stands as it is.
Thank you. Thank you. Aaron, I wanted you to comment because I think he's making it very clear on that as well. But we have also IBC directors right now who are in acting capacity.
Yeah.
From the CEO, we know also there's Joyce Ekwam, Obadiah Kosetani, amongst others as well. Now we are seeing people heading towards the court. You know, this is raising legal minefields along the way. Yeah, if you don't put your house in order.
You know, now the challenge we have with IBC, and I've mentioned this previously, is that while in 2017 we had a firm secretariat but a weak commission, that is at the commissioner's level, the reverse is actually the converse is actually true this time. That while we were able to put the commissioners at least in good time, not the best of timing, because if you remember what Kriegler advised us way back in 2008, is that have these people in office at least 2 years before the general election. This time, we have a bigger challenge because it's actually the secretariat, which is actually that's the main workhouse.
Yes.
You know, that's where the bolts and nuts are tied in terms of electoral management process, is not firmly fixed. Will you believe it, as you have rightly pointed out, that even up to now, 4 months to the general election, IBC doesn't have a substantive CEO, and I think it's a failure on the part of the commissioners. As soon as they were sworn into office, which is about 2 or 3 months ago, if I'm not wrong right now, that should have been their first order of business, so that you get somebody firmly in position and they begin running the secretariat. You know, even if you're a genius of what magnitude, to be given an assignment in a new posting and expect that within 3 or 4 months you'll run a national-wide exercise that involves nearly 100,000 officers out deployed, with workstations of almost 40,000, you know, that's not a simple exercise. Even the military will struggle despite their prowess at handling very difficult assignments. And therefore, it casts the commissioners of IEBC in very bad light. And I hope that Kenyans of good will begin to put pressure on them, just like we are doing on the show this morning, that it is wrong that up to now they haven't fixed the various directors, including the CEO, family in their positions. That this situation shouldn't obtain for perhaps the next 1 or 2 weeks.
Right.
I have to come back to our favorite tiff with Otiende about this opening of the Sabbath. You know, I've told you on many occasions that I understand Otiende. He is IT illiterate. That's why his understanding of opening the Sabbath, he believes it is a particular room where it needs to, you go and virtually open it and check the results that are in. I have told him, and I don't hold brief for IBC. My position back then, and you remember that morning we were considering something that the IBC, a communication they had issued. I've tried to quickly find it, I couldn't. That according to them, they felt that they had fully complied with the orders that the Supreme Court gave, that there were certain login credentials they thought needs to be availed to the parties. Only that at that particular point, when they were being asked to present them in court, they said many of these things, they'd take time. And if you're IT literate, you'd understand that there's various safety nets you put into a particular system which shouldn't be just easily available. But over the period of time, they were able to make it available to the parties. Therefore, to the best of my knowledge, and those who are IT savvy, those servers were open. But for those who struggle with understanding what a server is, like my good friend Otiende, they think it is a particular room which Chebukati has refused to open. I want to safely inform him that that is not the case. Finally, there's something that we need to mention about. Is this continued interference? And this is not something that has been captured by the papers, but it's something that the country needs to be alive to. If you read the main story, actually, which you guys ran with, what part of what the envoys sought to know from the Minister for ICT, Ukur Yatani, and Fred Matiang'i, was what they considered to be continuous interference into the operations of IBC by the executive, instead of granting them the necessary support, you know, in terms of budgetary funding and ensuring that the police provide the necessary support. There are many things that IBC Chair Wafula Chebukati has spoken to about publicly. Number one, in terms of budgetary support, in terms of the work that they need to do, that they continue to struggle and not execute their mandate fully, because they are not properly funded. Even the information that Otiende was seeking earlier on, saying that IBC has abdicated on its responsibility, I'm sure if you are to dig in deeper, they tell you that it's a budget constraint issue, because to carry out that particular process, they need particular funding. But the most important of which we need to speak out to, and I've seen the Deputy IG was part of that meeting, is provision of security and how you get police officers behaving. You know, we have a very bad culture which emanates from Fred Matiang'i, PS Karanja Kibicho, and the whole security apparatus, who have drilled into many of the top police service men in the country that there is what is considered to be government and not government. Yet before IBC, all parties are equal. Remember when we had the IBC, the Juja by-election, that actually the commanding officer in charge went and wanted to take charge of the tallying center, and it took the physical presence of Wafula Chebukati, the IBC chair, to inform them that this is an electoral management area and it's only IBC which can give direction. Those are the assurances that IBC needs to get from the men manning our security apparatus. That the police officers will only provide the necessary security support and not try to actually man the elections.
Dan Mazo, we need to just close up on that briefly. We look at the editorial cartoons as we wind up the show.
Yes, you know the issue of people in active capacity.
Yes.
You know, not only IBC is suffering from this problem, but many government departments are people who have overacted, you know, many months, still active capacity. So I believe the relevant bodies should take the necessary action. And the matter of IBC is more sensitive because IBC is conducting elections, and the outcome of elections is very important for Kenyans. So I think that's a matter whose action, quick action is needed, so that we have officers who are fully in charge and are responsible for their duties during the election. On the matter of security and elections, that's a very serious matter. A lot of times you cannot draw the line to what extent a security personnel should be involved in the election. Remember, the main idea is to make sure that the elections are safe, the officers, IBC officers are safe, there is no interference. And that's why in every police station there is assigned a security officer, all the way to make sure that the whole matter proceeds fairly, and that there is security and there is no unnecessary and undue interference, and that all the officers in a police station are able to deliver their job and do it without interference. Otherwise, there are situations whereby there is a security lapse, and an election turns chaotic. You saw in the past, like when somebody, quite a number of people, find their names are missing on the voters register, and yet you are very sure you registered as a voter. It becomes very chaotic and needs quick management, because you have only a day to conduct elections, and you know you don't want to create a situation whereby everybody thinks that the election is being rigged simply because it is chaotic, and the pollers, the people conducting the polling, are not safe or are interfered with, or the material is interfered with. So the government has really got to secure that and make sure that it is transparent, it is open, and there is no interference with the electoral process.
Right, thank you. Okay, so we want also just to tease out what Otende Amolo was talking about here on the summons of IBC, and you can see this particular summon from them as well. This is a letter. Honorable Sabina Chege, County Woman Member of the National Assembly, Muranga County, and it says, whereas the Commission is seized of a report and material against yourself in regard to violation of Clause 6A, subsection A, and 6, subsection I of the Electoral Code of Conduct, you hereby required to attend the offices of the Commission at Anniversary Towers, 6th floor, on the 15th day, which is today, of February 2022 at 9 o'clock in the forenoon for examination, or it should be in the forenoon, in the examination by the Electoral Code of Conduct Enforcement Committee over utterances made by yourself at a public rally in Isibuye within Vihiga County on 10th of February 2022. Issued on this letter is issued on that 11th of February 2022. Secretary Electoral Code of Conduct Enforcement Committee. You want to talk on this, City Council?
First, just to wrap up what we were talking about, Aaron Cheriot must be one of very few Kenyans, if not the only Kenyan, who got the access code from IBC to open the servers. And obviously we must assume that therefore he did. He actually managed to access the servers. So in our next meeting, it would be interesting if he shares with us and the rest of Kenyans what he found. Because the rest of us have never been furnished with those access codes, contrary to what he says. And that's why we've never been able to access them. But on this one, as I mentioned, I will not talk much about it because I'm going to accompany Sabina Chege to IBC. Let me just say two things. One is that in addition to that summons, they sent yet another letter now explaining the basis of their summons. Because this summons is quite general. A summons is usually supposed to be very clear and particular on what it is. Now, they sent another letter which is now not a summons, but which now purports to explain what they are calling the breach. And in it, they are referring to some utterances she made that some people may have claimed that, the election was stolen and all that. Let me just, on that, let me say two quick things. One is that the invite is going to raise very interesting issues, which I will not really talk about right now, about, the jurisdiction of IBC, about their own regulations, about how they can do this, including about whether they can question somebody about the results of 2017 when they themselves have never made it public. Only the second results were now, made the second election. But beyond that, let me not comment because I'm accompanying as one of our lawyers.
All right, thank you, thank you. We want just to wind up on that as well, and by looking at the editorial cartoons, and we'll begin with this that we have on inside the Star page 2. This is Of course, yesterday was Valentine's, and we can see Uhuru Kenyatta here with a bouquet of flowers, if we may just put it up briefly, going to the door of Mount Kenya. And the person who's walking away from there, if we may just have it, is William Ruto, who beat the other one to the punch in terms of getting Mount Kenya. Aaron Choriot.
I think basically what the cartoon says is that
someone was in the bedroom of Mount Kenya first.
He's late to the party. That,
he's late to the party.
The lady has left with the gentleman who appeared first and convinced her. By the time the other gentleman arrives in Nairobi lingo, you'll find that his fare has already been eaten.
I did them all briefly.
You know, what I see there is different. You know, the color of love is red. And usually you give red roses on Valentine's. So when you see a man who has sneaked in yellow roses, that is fraudulent. But Dibal, we also need more peppers so that we can be seeing these things by ourselves. So, you know, so we don't have to strain. We need the full range.
We know this is a standard group, but I mean, don't limit us to reading your papers alone. I mean, it's not fair.
It limits our discussion.
Tell your producer to give you more newspapers.
Okay. Well.
And from the other media houses, they shouldn't be mean to a point that they say, oh, in this house you only read a particular, you know, honestly.
There should be some brotherhood and sisterhood.
Brotherhood and sisterhood.
Yeah, in other quarters where we've been with you, remember, we used to read the Standard, and yet they are your competitors.
Thank you.
And in that cartoon, you know, William Samoei Ruto is running away from Mount Kenya, wearing yellow, which is the same color as the flowers.
Is he running away? Maybe he's finished his business right away. So. It's done and dusted.
It's done and dusted. It's over.
Thank you, Aaron Cheriot. Really appreciate you coming through. Also, Dr. Otene Molo Seneca, so thank you for coming through as well. And Dan Amazo, thank you for coming as well this morning. Very a wonderful treat every Tuesday that you give us here on Siasa Fiesta. We really do appreciate it. Of course, you can continue with the conversation on social media as well. Remember, our hashtag is the Morning Prime. Also at KTN News KE. That is the Twitter handle that you should use. Thank you very much for your valued company. We continue pace with the conversation on Morning Prime. Don't go away. Much more coming up on the other side of the break.